Good evening, everyone. This is Pooja Arora welcoming you all to this exclusive webinar on understanding freedom of speech and expression in India. We are sitting in a country where we have a freedom of speech, and the same is being quoted, and it comes in front of us a lot of time. Understanding the same and understanding with the need of an hour, Media and Entertainment Skills Council and Global Media Education Council has come up with this series of 30 sessions, out of which today it's very lovely talking about the freedom of speech and expression in India. And we have with us Dr. Juhi P. Pathak. Dr. Juhi P. Pathak is assistant professor with Shada University, and she's also an author and a specialization in print, at Altruist Center of Research, Training and Development, which is ACRTD. Dr. Pathak has more than 10 years of teaching and research experience across prestigious state and private universities. Prior to teaching and research, she worked for a brief period with Navi Mumbai television channel and had freelanced for DNA newspaper in Navi Mumbai. And there's a lot more I can talk about Dr. Pathak. So instead of wasting your time, would love to invite Dr. Juhi P. Pathak, please. Juhi ma'am, you're most welcome on this platform.
Thank you so much. It's a pleasure to be again coming on a platform where I'm already a working committee member of GMAC. And this is for the first time that I'm also been invited by MESC. So which is a privilege, and thank you so much. Thank you for the opportunity.
Thank you. And we have Dr. Amrish Saxena also with us. He's a renowned journalist, author, anchor, and sir has been with us in this journey and he's supporting in the series. So welcome, Amrish, sir.
Thank you.
So it's so good to have you here. So
shall I start my presentation?
Yes, ma'am. I'll hand over the session to you. The session is over to you. I'll be here learning at the back end. It's over to you. Thank you.
Thank you. So the topic that I have chosen to speak on today on this Vidyadan portal is understanding of freedom of speech and expression in India. It is very important that we understand what the Indian Constitution provides us with regards to a very important fundamental right to each and every citizen, and that is the freedom of speech and expression. So how does this concept originate? Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states clearly that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media, regardless of the frontiers. So the three distinct aspects of this freedom includes the right to seek information, the right to receive information and ideas, and also right to disseminate and impart the received and sought information and ideas. Where do we find freedom of speech and expression in Indian context? This particular fundamental right is enshrined in part 3 of the Constitution, Indian Constitution. So how many parts do we have in total? In India, the Constitution of India, it has 25 parts, and also we have 12 schedules. Now, out of the 25 important parts, part 3 deals with fundamental rights. So fundamental right, the chapter, the part is from Article 12 to 35, and specifically the fundamental rights are enshrined from Article 14 to 32. We'll not go into the details of the fundamental rights due to paucity of time here. Now, what is Article 19.1? So Article 19 here, students normally they make a mistake that, they state Article 19.1 or Article 19 as freedom of speech and expression. Article 19 is not, but it is not specifically of freedom of speech and expression, but it is an article of 6 freedoms. What are the 6 freedoms? It is the freedom to speech and expression, which is Article 19, Clause 1, Subclause A. That is how we read it. Number B is to assemble peaceably and without arms. C, to form associations or unions. D, to move freely throughout the territory of India. E, to reside and settle in any part of the territory of India. And the 6th freedom is to practice any profession. Why did I omit point number F? Point number F was omitted because it was earlier the right to property, which was a fundamental right, but now it is just a legal right under Article 300A. If you can see, I have inserted a capital letter A here because that A stands for amended article. So this 300A was inserted later through an amendment. Currently, we do not have right to property as a fundamental right. So we are left with Article 19.1, which is article of 6 freedoms only, of which the most important topic that we are discussing today is Article 19, Clause 1, Subclause A, to freedom of speech and expression. If you can see here, Article 19.1A is a very simple article. It just states that this particular right is available to all citizens of India, and so which also means that it is not now currently talking about the aliens or the foreigners here. Alien is a concept that we use in legal parlance, which denotes foreigners. But this right has been particularly given to all the citizens of India. Now, along with this, Article 19.1A, if we have to understand in its entirety, we have to understand a very important article, which is Article 19, Clause 2. So what does Clause 2 state? It states, here I would be reading the original provision and then giving an explanation simultaneously. So nothing in subclause A of Clause 1, which is Article 19.1A, freedom of speech and expression, shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of sovereignty and integrity of India, the security of state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. Now, if I have to break this slightly complicated provision, it states that the state in this context does not only include the legislative authorities of the union and the state, but also other local or statutory authorities or municipalities or local boards, etc., within the territory of India or under the direct control of the government of India. Now, what does it state? It states that the Article 19, Clause 2, it states certain reasonable restrictions. I will come to the word reasonable after in the upcoming slides. And what are these reasonable restrictions? That we will not say any statement which will jeopardize the sovereignty and integrity of India, the security of state, friendly relations with foreign states, public order, decency, morality, and also will not be in direct confrontation with contempt of court, defamation, or incitement to an offense. Coming to this, so here, these are the reasonable restrictions. Now, the next point that I want to deal elaborately is what is reasonable in this reasonable restrictions. Before that, it is very important that we know that there were 3 drafts of the Indian Constitution. One dating as far back as 1895, which is prepared by Sri Bal Gangadhar Tilak. The second one was around 1925. It was known as the Commonwealth of India Bill. And the third one was prepared by Sri Motilal Nehru in the year 1928. So during the year 1947, there were 4 drafts of the Constitution of India prepared by Professor K.T. Shah, K.M. Munshi, Harnam Singh, and Dr. B.R. Ambedkar. Here, it is also very important to understand the contribution of Sri K.M. Munshi, because it was his draft that laid the foundation of the restrictions, which are the areas that limit the freedom of speech and expression and other fundamental rights under Article 19(1). His draft constitution had this particular statement that there should be restrictions that would limit the fundamental rights, including the right to freedom of speech and expression. Now, the word reasonable was not incorporated until the first amendment of the Constitution, our Constitution, the Indian Constitution, that happened in the year 1951 in the month of June. And it was almost 17 months after the Constitution of India was enforced on the particular date, 26 January 1950. So after almost 17 months, the first amendment takes place in June of 1951. And we get this new term, reasonable, incorporated prior to the word restrictions in the Indian Constitution under Article 19, Clause 2. Which means that when the Constitution was enforced, we did not have the term reasonable restrictions there. But just before the enforcement of the Constitution, one Pandit Thakur Das Bhargava, we have to remember him. His name is very important. It was he who wanted the term reasonable restrictions and not restrictions under Article 19(2), because he felt that the liberty of any Indian citizen would be jeopardized if we do not use the word reasonable and just use the word restrictions, and that would limit the fundamental rights under Article 19(1). Now, there is always an allegation that the first amendment to the US Constitution outrightly gave them the fundamental right of freedom of press along with freedom of speech and expression. But in India, the first amendment to the Constitution was something that was to restrict the fundamental rights because of the word reasonable restrictions was incorporated in that particular amendment. There is a historian, constitutional historian, Granville Austin. He said that K.M. Munshi and Sir Aladi were responsible for bringing in the restrictions. But this allegation was proved later to be kind of wrong, because K.M. Munshi had, throughout his later debates during the drafting of the Constitution, he had changed his position from somebody who wanted restrictions on fundamental rights and to becoming somebody who later was known to remove sedition from the reasonable restrictions. So his position has changed, but it would remain as a fact that it was K.M. Munshi's draft of the Constitution that was taken as the basis for incorporating the reasonable restrictions in Indian Constitution. Now, so that is the contribution that each member, right from Bal Gangadhar Tilak to the 4 stalwarts, K.M. Munshi, Professor K.T. Shah, Harnam Singh, and B.R. Ambedkar. And finally, we get the reasonable restrictions in the form that we know today, that is under Article 19(2) of the Indian Constitution. So that was something that I really wanted to elaborate on, because not many of us, we know the history behind what we have today as the reasonable restrictions to freedom of speech and expression. As I said, in Indian context, a need for freedom of press was illustrated not directly. So we use the word explicitly. Explicitly means not in black and white. It's not there in the Indian Constitution, but it is supposed to be interpreted implicitly, which is within the meaning of Article 19, Clause 1, Subclause A, that is freedom of speech and expression. So what is the need for freedom of press? The liberty of the press is essential to the nature of a free democratic country. The press cannot be used for any bad purpose without incurring a suitable punishment, whereas it cannot be used for any good purpose too, under the control of an inspector. So who's an inspector here? Inspector is somebody who is a censor of sorts. You cannot, the press should be allowed to function as its own guardian, which is also there is a concept called as self-regulation. So what do we mean by this term freedom of press? It means to collect information, to report news and information, to print and publish news, to distribute and circulate such printed and published matter. Freedom means absence of control, interference, or restrictions. Thus, freedom of press means the right to print and publish without any interference from the state, government, or any other public authority. But as we just discussed, this freedom is not absolute in nature. We have the reasonable restrictions under Article 19, Clause 2 in the Indian Constitution, and that is applicable to not only freedom of speech and expression of individual citizens, but is also applicable to press. So, freedom of press in India. Article 19(1)(a) is the foundation of freedom of press in India, although the term press is not directly mentioned in it. As I said, it's not explicitly, it's not mentioned in black and white, in written form, but it is understood. How it is understood? It is understood through special judgments and pronouncements, such as Express newspapers versus the Union of India, Sakal papers versus Union of India, Bennett Coleman versus Union of India, Ramesh Thapar versus State of Madras. We will be discussing, if time permits, all of these cases in the upcoming slides. The Supreme Court has mentioned and maintained in the above mentioned cases that the term freedom of speech and expression includes the term freedom of press, which is to collect, print, publish, and circulate information with complete freedom. Case studies. We just mentioned the case studies. So what are the case studies? Suppose if we talk about Sakal papers versus Union of India, there was a particular law act that was enforced, the Newspaper Price and Page Act, which was challenged by this newspaper, which is Sakal newspaper. The act enabled the central government to regulate the prices of newspapers in relation to their pages and size, and also to regulate the allocation of space for advertising matters. Now, it is very logical to comprehend and understand that if, for example, I am given only 4 pages to publish my content, and I was expecting that my content would be out in 12 pages or 24 pages. So which means it is a direct curtailment to my content. And the moment you curtail my content, you are curtailing my freedom of press, you are curtailing my freedom of speech and expression. You cannot make me comprehend and constrain my content, which is supposed to be for X number of pages, 24 pages, N number of pages, and you're making me publish only 4 pages for that matter. So that was a direct threat to freedom of press, and Sakal papers had challenged this Newspaper Price and Page Act. So definitely the court held that the act and the order were void, being violative of Article 19(1)(a) of the Constitution. Similarly, Bennett Coleman versus Union of India. The petitioners here challenged the restrictions imported by newsprint order under import order of 1955. Now, I'll explain it to you in a very layman's language, that newsprint is the paper on which the newspaper is printed and published. So the moment there is a restriction on import of the paper, you don't give me paper, how will I publish my paper? How will I print my newspaper? So immediately the major challenge is that you are not giving me the means on which I can publish and print my newspaper and later can be circulated and disseminated to the larger public here in context. So the petitioners, Bennett Coleman, immediately challenged this import order of 1955, the regulation of sale, acquisition, and use of newsprint under the newsprint order of 1962, and the direct regulation of size and circulation of newspapers under newsprint policy of 1972-73. They contended that this orders directly affected the right to freedom of speech and expression. And as is expected, the Supreme Court of India accepted the contention and struck down the orders as unconstitutional, as void. So what does Express Newspapers versus Union of India state? This case concerns the writ petitions. We will be, if time permits, I will also be elaborating on what writ petitions are, and challenging the levy of an import duty on newsprint. Similarly, as I said, if you do not give me the means on which I can print my paper, on which I can publish my newspaper, it is a direct challenge to freedom of press and also simultaneously freedom of speech and expression. The Supreme Court of India allowed the petitions and directed the government to re-examine its taxation policy in the light of the effect it had on freedom of press. Ramesh Thapar versus State of Madras. This is another interesting case. So, like we already discussed, that what does freedom of press include or comprise of? It not only comprises of freedom to print, publish, seek information, give information, but even if I'm able to print, if I'm able to publish, but you do not allow me my circulation, if you restrict the places, the areas where my newspaper was supposed to be distributed, then that also accounts for a very important restriction to my freedom of press. The petitioner was the printer, publisher, and editor of a journal in English called Crossroads, printed and published in Bombay. Under Section 9(1)(a) of the Madras Maintenance of Public Order Act 1949, the entry and circulation of the journal was banned in the erstwhile state of Madras. In response to this ban, the petitioner filed a writ petition before the Supreme Court, averring that the powers under the Act were an excessive restriction on freedom of press. I will not elaborate here, but as I said, you are allowing me to print, you are allowing me to publish, but you are not allowing me to circulate. And that also is an important area where the freedom of press is restricted. So I would now stop my presentation here and have a discussion on what is the concept of hate speech and freedom of speech and expression. We have seen all the slides. We have also seen that there was no mention of hate speech in any of the reasonable restrictions. So do we understand from this fact that hate speech is allowed under, and it is not considered as reasonable restrictions? Definitely no. It is a big no, because hate speech, and it is surprising that there is no definition of hate speech as such given in the entire Constitution. We have the definition of hate speech in it was given by the Law Commission. The Law Commission had stated that in its 267th report, if I'm correct, hate speech is any word, written or spoken, signs, visible representations within the hearing or sight of a person with the intention to cause fear, alarm, or incitement to violence. So this hate speech definition was given by the Law Commission. Please note down if you want to, in its 267th report. But so don't we have any other provisions of hate speech? We do have. Indian law does have provisions to hate speech, and those provisions are there in the Indian Penal Code 1860, and also they are enumerated in the Criminal Procedure Code, CRPC, as we call it. So Indian Penal Code, I'm not sharing it in a PPT format, but I'll just quickly run you through the provisions of the Indian Penal Code, which talks about hate speech. It's in section 153A, A capital A, which is an amended article. It states that promoting enmity between different groups on the grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to the maintenance of harmony is considered to be hate speech under the Indian Penal Code. Similarly, we have section 153B, which is imputations, assertions prejudicial to national integration can also be considered to be hate speech. We have section 295, which says injuring or defiling place of worship with intent to insult religion of any class is also considered to be hate speech. Section 295A, it states that deliberate and malicious act intended to outrage religious feelings of any class by insulting its religion or religious beliefs is also accounted as hate speech. Section 298, it states that uttering words, etc., with deliberate intent to wound the religious feelings of any person. So all of this, and there is another section 505, which states statements conducting to public mischief with this motive and intention to create public mischief will also be counted as hate speech in IPC, which is Indian Penal Code 1860. So can FIR be lodged against hate speech? Yes, FIRs are lodged for hate speech under section 154 of the CRPC. And it states that you can, if anybody is feeling aggrieved that his entire reputation, his religious beliefs, or anything that he feels very close to his individuality, if it is jeopardized through malicious use of words by another party, a third party, then he is liable to lodge an FIR, which is First Information Report, under 154 section of the CRPC, and also all the provisions that I just listed out under IPC 1860 also. So do we understand from this deliberation that hate speech provisions are related only to IPC and CRPC? No, there are other laws also, other legal provisions also, like the Religious Institutions Prevention of Misuse Act 1988, the Cable Television Network Regulation Act 1995, Cinematograph Act 1952 prohibits and regulates the means of hate speech in India. We cannot, just because we want to offend somebody, we are not permitted to be using hate speech. The most important Supreme Court judgment that here I would like to bring to everyone's notice is Shreya Singhal versus the Union of India provision, the judgment, which had differentiated between three forms of speech. It is this judgment, if we read, we find here the classification of speech. That is, number one, discussion, number two, advocacy, and number three, incitement. So as long as you are discussing a topic, as long as we are advocating a topic, it is not hate speech. But the moment we incite, incitement is the key to determine the constitutionality of the restriction of free speech. So you cannot be inciting anything against any person, group of person, class of person, anybody. But we can freely discuss and advocate whatever we want to in the light which is within the reasonable restrictions. Are there international efforts also to curb hate speech? Yes. The Council of Europe sponsored no hate speech movement actively, which raised awareness about hate speech in order to help combat the problem. Yeah, if I am sure all of you who uses Facebook, Google, Microsoft, Twitter would also know or are probably aware that on May 31st, 2016, all of these social media platforms jointly agreed to a European Union Code of Conduct obligating them to review the majority of valid notifications for removal of illegal hate speech posted on the services within 24 hours. So if you flag it, they will review it. And after reviewing, if they find that the particular post or tweet was advocating hate speech, then they have obligated themselves to the European Union Code of Conduct that they will remove it within 24 hours flat. So apart from this, various country governments are also bringing social media rules to tackle hate speech problem from the social media platform. So with this, I think I have made an exhaustive presentation on understanding freedom of speech and expression in India. Sir?
Yeah. It was indeed a very exhaustive, because you covered almost all aspects of freedom of speech and expression, including the latest things, which is about hate speech. But still, there are problems which I believe are there in the freedom level, because freedom, when we say freedom of speech and expression, obviously when the constitution was made, at that time the media had not expanded the way we find it today, and the arrival of internet has changed everything. And not everything is possible to be amended, to be included in the constitution. But then the digital space and the social media, that is making all the difference in today's time of freedom of speech and expression. And I believe that most of the cases that we find today are happening with regard to restrictions by the government and all. That is happening in the digital space. Particularly, we hear every other day some kind of problem is happening on the Twitter, and somebody would have made a tweet, and some IPC provisions are imposed, some sedition charges are imposed. What would you say on this particular aspect, wherein in the name of regulating the digital media and the social media, a lot of such provisions of the criminal justice system or the Criminal Act, IPC and CRPC, they are being imposed. So how any one such person who is new to the area and who want to write something, to express something, how that person can exercise his or her freedom in such kind of situation wherein from the government side or from the administration side, the things are not that conducive for making an expression. What would you say on this?
So in India, we do have cyber laws in place. We have the IT Act 2000, which was amended in 2008. And there was a provision. It's very interesting, sir, that because you brought it out, I'll share it here. That there was a provision, section 66 A of the IT Act, which spoke about hate speech here, which spoke about how you cannot misuse the cyber platform for your own incitement or bringing in public disorder purposes. Now that thing, that entire section was removed under a judgment of the Supreme Court in 2016. But it is very, I would say, very funny, I would say, that not many state or authorities or were knowing about this deletion of this provision 66A, which was on the page number 24 footnote of the judgment that I'm talking about, and they still kept on holding people accountable under these provisions. And it is there is a data, you can go and check. I would not know the figures exactly. Around 1,000 people the trial is going on in courts and various levels, and they are unaware that this particular provision under which people are being held accountable for and trials are going on, neither the people who are accused, alleged, are knowing that they are being punished or tried for a provision which has been completely declared null and void by the Supreme Court. And this section 66A, which is an important provision of the Cyber Act, which is the IT Act 2008 amendment, that holds this cyber platform, the social media platform. It has various provisions. There are the amended provisions are the most important ones, because the previous provisions only spoke about hacking, getting into the source of the system, or authorities trying to crack system code, important passwords. Because we have to also understand that 2000 was an era, a decade where social media was not so much dominant, and because we can see the rise of social media platforms in the second decade, that is 2010 to 2020. So then the social media platforms have their own self-regulatory codes as well. It is very it would be wrong to say that OTT platforms or other social media platforms do not have regulations at all. They have regulations, but those are self-regulatory codes and conducts and norms. So if you talk about Netflix, if you go and see their privacy policy, there is an exhaustive privacy policy on Netflix, on various other platforms. As I said, in 2016, Facebook, Twitter, your Instagram, every social media platform that you see have their own privacy policy. You are not able to open an account unless you accept. The problem here is the mindset. We do not even read what we are accepting. So we just accept because we want to get into the social media platform. But there is a exhaustive list that comes that you have to give your consent to, that you will agree to this rules, this privacy policies of the platform, and then post content. But they have a measure to curb the posting of content even after you have logged into the platform. So then, as I said, within 24 hours, if they find your post or anybody has raised an issue or flagged or reported your post or your content, then the onus is on the platform that they will be removing it. And more so, you would also be banned from the social media platforms for a few days, and depending on the kind of content you're posting, and they will block you. So that is what you have to take care. And it would be wrong to say that social media platform is unregulated platform. It is not, because the Indian law also under the IT Act, the Cyber Act that we have, regulates the platform. And individually, there is this concept, and we're talking about freedom of speech and expression, we're talking about freedom of press. So it is also, we have to respect self-regulatory codes also. So the social media platforms, they go for self-regulation.
Yeah, so Dr. Juhi, whatever you said is perfectly fine as far as law is concerned, as far as the regulations are concerned. But the real problem in a democratic setup is that everybody gets an opportunity to express himself or herself within those limits. But then even within those limits, there are problems because there are repressive tactics which are applied on the freedom of the press. So any student or any teacher who is new to the system, who is new to writing and posting. So he or she does not know that where he or she will be landing in trouble for writing certain things, which he or she might be thinking that it's well within the rights which are guaranteed in the Constitution as far as freedom of speech and expression is concerned. So can you suggest certain measures to the young people, what precautions they should take while they are making some expressions so that they are not trapped in the clutches of the law?
So, to students, the only word that they have to take care of is malicious intent. The phrase, unless if you keep your conscience, if you keep your intent clear, then you would probably not write anything that your conscience would not allow you to. So that intent has to be very clear. Now, sir, I will also cite one example because again, you raised this question. There is this example of, we call it the Palghar girls. So in Bombay, what happened when Shri Bal Thackeray had passed away, they had declared a complete bandh. And one of the girls just posted on Facebook. So Facebook also asks you, right, what's on your mind? So, and she posted that I am unable to understand why there is a bandh on this date. A very simple question that she has posted. Now, and another friend of hers, out of some, agreement or consent or just out of friendship, probably liked that post on Facebook. So immediately both of these girls were booked under violation of freedom of speech and expression, that they were hurting sentiments of public, Maharashtrian public. Now, this is one episode. What happened later, there was a case filed, whether these girls were recruited or not. But this incident of Palghar girls is very important, that a simple comment on Facebook and forget comment, even liking a post could land them to trouble under a provision, which is the reasonable restrictions. So whenever we are writing something, whenever we are posting something, first thing, the foremost underlining, defining phrase that you have to keep in mind, am I hurting somebody? The moment, am I defaming somebody? Defaming means manhani. Samman mein case pahunchna is defaming. So is my word, is my statement harming somebody's fame, harming somebody's reputation? Am I saying something which is going against the court of law? So that would land you up in contempt of court. And also a brief understanding. And that is why, sir, we think media laws and ethics is a very important part of the syllabus of our courses, media courses. We have to understand, we have to teach our students that there's a certain provision, sedition, defamation, contempt of court, public order, morality, decency. These are some things that are not to be violated. The moment you violate, there would be problem. So better, precaution is better than cure. Why to cross the line and fall into a trap and then find the precautionary measures? Then please save me. Why should you even cross the line in the first place? Lakshman Rekha ke andar rahenge, surakshit rahenge, safe rahenge. So that is what I think. And this Lakshman Rekha is given to us by our constitution, the reasonable restrictions under Article 19, Clause 2. You follow that, you are safe. And that is what I believe, sir.
Yeah, so I agree completely with you, and obviously with all your presentation and the vital information that you provided in this session will be handy for all those people who aspire to be in media education, who aspire to be budding journalists, communicators and all. And they all understand the kind of freedom that has been guaranteed to us, to the citizens by our constitution framers, which is really very, very rare, very vital, and which is also in consonance with whatever constitutional democracies provide us. So one should always be ready to make use of that. And with the social media at our disposal, all young people should keep on making the expressions, writing something, making something, making some audio, some podcasts can be made, some videos can be made, and some YouTube can be made use of, because democracy thrives on the dissemination of information, and that should be done by all the citizens. It's not that the information creation and generation is in the hands of a few media houses and all, because internet has provided us a tool, and we have entered into that phase of citizen journalism wherein each one is a content creator. So we all should take that responsibility of disseminating all that information which is in the larger interest of the society. So I thank you once again to Dr. Juhi Pathak to be in this session and talking about freedom of speech and expression in such a detail, which is the cornerstone of our constitution or the entire democratic system. So we thank her for this session, and I must also reiterate the way that these sessions have been planned. This is really a big endeavor wherein this MESC, this Media and Entertainment Skills Council, has collaborated with GMAC, Global Media Education Council. GMAC organized the 75 sessions series, which was again to create a storehouse of knowledge and creating awareness on such vital issues which are really necessary for media education. And this time it is completely a different kind of series wherein 30 lectures will be presented by distinguished media educators and researchers on different subjects, because ultimate goal is to pass on this information, this awareness to the young minds, so that they are the futures of the country. If they are equipped with all that information which is necessary, then it will create a better society and it will enrich media education and media industry. So I finish with this today's session, and I will request Dr. Juhi Pathak to also make an announcement regarding the next session under this series.
The next speaker that we have is Florence Handik Rabha. She is an assistant professor and head electronic media and anchoring, Royal School of Communications and Media, the Assam Royal Global University, Guwahati. And her topic would be development communication for the upliftment of human society. So that would be our next session, which is on 10th October 2022 at 7 p.m. Please stay tuned, and you would be seeing her on the other side on 10th. Thank you, sir.